month. So I will give you the summary version of it, which is also available on your page 328 of your textbook. So please refer to that. Yeah, this is the process. Rest of the process is now explained in detail in your chapter, but you don't really need it. You just need this process at glance. So now we come back to our open offer. We have, remember, 4 types of open offers: mandatory, voluntary, conditional, or delisting. Whichever open offer you are making, first appoint the intermediaries. The most important intermediaries here is the merchant banker, who will help you in finalizing the compliances and price. So make that public announcement. It will either be a 26% public announcement or a minimum 10% public announcement in case of a voluntary open offer. So send a copy of this public announcement to all the stock exchanges and to the target company. And within 2 working days of the detailed public announcement, you open a escrow account. So there are 2 public announcements here: short public announcement and detailed public announcement. The first public announcement here is short public announcement. You just give a summary that you are going to buy this much shares of this target company. Then you open escrow account and you deposit money based on the escrow account requirements. Within 5 days of the original public announcement, so SPA to DPA is 5 working days. Within that, you make the detailed public announcement stating how much price you will pay for these shares, which bank is helping you, which merchant banker is helping you, etc. And 2 days before the detailed public announcement, you should have deposited the money in the escrow account. Once this process is done, the process goes back to your buyback type of a status. There you filed a draft prospectus. Here you will file a draft letter of offer. Whenever you buy shares, you file letter of offer. Whenever you issue shares, you issue offer document, which is also called as prospectus. That's the only difference. You're not issuing shares, you're buying shares which are already existing, so you will file a draft letter of offer, and just like draft prospectus is filed with SEBI, draft letter of offer will also be filed with SEBI, and this should be done within 5 working days of the details public announcement. Then you dispatch the letter of offer based on SEBI comments. Remember, after draft, SEBI might give you some changes to make, and then you might actually end up making these changes, and then you will have the final letter of offer. That final letter of offer should be dispatched within 7 days of receiving any comments from SEBI. SEBI usually takes 30 days to give you the comments. Then you may revise the offer price prior to at least 1 working day before the tendering period. If you remember, tendering period is part of offer period. Offer period has already started because you've already made the announcement. So before tendering period, if you want, you can increase the price so that you can attract more investors for this particular offer and your offer is successful. Then within 2 working days, you have to now submit the recommendation of your company's independent directors. What do they feel about this acquisition? Do they feel this acquisition is required or not? Their opinion should be submitted. Then the tendering period starts. In the tendering period, the shareholders of the target company will start sending their share certificates and demat account details with a debit declaration to you in your favor, and it will start 12 working days from SEBI comments, not later than. So if SEBI gave you comments, you would have submitted the draft letter of offer. You should ideally submit it immediately in one day. And then from SEBI comments, you have 12 working days to open the tendering period. And this tendering period will at least be live for 10 more days. So you'll get people 10 days to make these share certificates reach you, make those demat account debit notifications reach you, and then once you receive all these share certificates and demat requests, you will then close the tendering period and pay the money for their shares that you have included in your letter of offer. So within 10 working days from the last date of the tendering period, you should make the payment to all the shareholders that have participated. If not, you will have to then refund the entire money. Once the payment is done to all the shareholders, their shares will become your shares. You are now the owner of the shares of many of the public shareholders of the target company. So now you have to make an announcement saying that yes, the offer period is closed and we have successfully acquired X number of shares from the target company shareholders. This is what is the process of takeover for this particular chapter. In the escrow account, always remember you have to deposit money in the escrow account, which is extremely important. Where is it? They have not given? Okay. I guess they have removed the escrow account requirements. Yep. So SEBI can pretty much ask you to not follow this entire process if it feels that your acquisition should be done on an urgent basis. So SEBI might exempt you automatically from following any of this process, and that is your entire chapter. Alright? So you have to remember the process. Apart from the process, you have to remember what is the different types of open offer, what are the different disclosures there are 5 disclosures you have to remember, and you have to remember the 10 or so definitions. So 10 definitions, 4 types of open offer, 5 types of disclosure, and 1 process. That gives you about 20 points to be remembered from this particular chapter. Are we clear? Any doubts or queries, please let me know. Otherwise, we can move to another chapter. Right? I'm surprised that all of you have understood this. Either all of you have understood this very well, or you have not understood absolutely anything. So if you have not, please do ask. Otherwise, we'll move on to another chapter immediately. Let's do a smaller one. Okay. Let's do prohibition of fraudulent and unfair trade practices. Now, this chapter is very simple and straightforward. We have seen in chapter 2 for SEBI that one of the objectives of SEBI was to prevent UTP and FTP along with insider trading. So insider trading is chapter 13, the chapter before this. Chapter 14 talks about UTP and FTP. Any person who tries to commit a UTP or FTP, SEBI has been given the 3 I's: the power to inspect, the power to investigate, and the power to conduct inquiry. This we saw under the powers of SEBI. So now we are going to learn how SEBI is going to use this power to prevent unfair and fraudulent trade practices. This is one of the main objectives of SEBI. So whenever any person commits any UTP or FTP while dealing in securities. Dealing means buying, selling, or subscribing any security. When he knowingly influences the decision of investors, or when he provides assistance in influencing investors, or otherwise he does something unfair which does not allow SEBI to protect the interest of investors. If any of such act is done while dealing in security, such act is called as a fraudulent or unfair trade practice. Typically, it is going to be put under unfair unless fraud is proven. Fraud means intentional misrepresentation. You know that the company's price is going to fall, but you lie to your investors and you advise them to purchase the shares of that particular company. Many brokers, many investment advisors, many secondary market intermediaries have been caught doing this. So any act or any expression or any omission or even concealment of information, when you do this knowingly, then it becomes a fraudulent trade practice. Fraud means you know that something is wrong, but you portray that as right, and you know something is right and you portray that as wrong. Otherwise, it also includes a promise which is made without performing or completing the promise, a reckless or careless behavior, any omission, any deceptive behavior, or any false statement. All of these are considered fraud. Security law fraud therefore includes any misrepresentation, which means concealing truths and facts, any suggestion, buy this shares or sell this share, any active concealment when you're suppressing information, any promise to do something, any representation which is made in a reckless manner, any omission of data, any deceptive behavior, making wrong and false statements without reasonable grounds, and providing misinformation regarding the price of securities. All of this leads to it being called as a FTP. There are some exceptions. If the FTP was made due to the economic policy of the government, the economic situation of the country, trend in securities market, and it was made in good faith, bona fide is the word that they are looking for here. It should not be made in a malified intention. Not with bad faith, you just genuinely believe that the price of this company's share might go up or come down, or you should probably hold on or sell the shares. That advice was made to your clients, and your clients end up losing a lot of money because of that. Then you may be exempted from the fraud. So what is the penalty here? That's what this chapter talks about. So if you are caught doing manipulative, prohibitive, or unfair trade practices, again the definition is now given in detail here. SEBI has the power to do III, inspection, investigation, and inquiry, and for that they will be considered the appointing authority, and they will usually appoint some investigating authority or investigating officer to conduct investigation against such MTP, UTP, or FTP. That is the power of SEBI to order investigation. This investigating authority could be an individual person or an entity. SEBI will order them to conduct the investigation, and they have the powers of civil court. Powers of civil court meaning they can inspect records and call for information. They can take copies of these records and conduct inspection. They can also ensure that any books, registers, and documents are produced on time. They can keep these documents in custody So along with III, we had also learnt about search, seizure and confiscation. So seizure is allowed for 6 months, which can be extended for another 6 months on the order of SEBI. They can also take oral statements and examine witnesses, and they can record your statements. They can examine you on oath, just like a civil court. They can ask you to promise whatever information that you are saying is true to the best of your knowledge. They can even make an application to a judge and order a hearing through this judge, and they can take their permission to search, seize and confiscate any of the documents, and if they want, they can keep the documents for an extended custody also. Every company, every director, every officer and every promoter of the company has the duty to cooperate with such investigating authority. So if they ask you to appear before them, appear. If they ask you to submit a document, submit them. If they ask you to provide a copy, provide a copy. If they ask you to take oath, you have to take oath. Just cooperate with them as much as possible. Once this is done, so first, SEBI will appoint the investigating authority, which will conduct the investigation, and during the investigation, they can also have the power to inspect and inquire. Inquire means asking questions, inspect means inspect documents and records. After the investigation is done, make sure that as a company you cooperate with them, and based on this they will submit an investigation report to SEBI. This investigation authority, once it submits this investigation report, then SEBI will make a decision. What decision can SEBI make? They can suspend the trading of securities of your company. They can restrain people from accessing information. They can suspend any office bearer. They can retain the money earned from the selling and buying of these securities. They can ask an intermediary to not sell any of the assets that they have bought by entering into UTPs or FTPs. They can direct people to commit action, and they can prohibit people from disposing any of this information. So SEBI will, based on this report, suspend, restrain, impound, direct, prohibit any persons or any intermediaries or any company and its office bearers with respect to information. And once that is done, they will impose the penalties, and they can even call you for a hearing. That hearing, after the report is submitted, is called as summons. This summons notice will be issued to you either physically or electronically. Once you receive the summons notice, you have to make sure that you appear in front of SEBI within the time frame given there, and if you fail to appear, they will then send the summons notice in 2 newspapers having nationwide circulation. One will be in English, another will be in regional language, and that paper will be published in that area where they know the last known location of the person who has resided there. So that is what this chapter is all about. So first, SEBI is the supreme authority. SEBI appoints investigating authority under this chapter. SEBI and investigating authority both have the power to investigate, and during investigation they can inspect documents and people and inquire documents and people and take copies of the same, and even do search, seizure and confiscation. This investigation authority will submit a report. Based on the report, SEBI will issue a summons. If you don't respond to the summons, they will publish it in newspaper. Even then, if you don't respond, they will start taking action and impose penalty. And we already know what is the penalty for this. FTP and UTPs are serious offenses. So 25 crores or 3 times the profit made, whichever is higher. That is the penalty that will be imposed for engaging in FTP or UT. That is the purpose under this particular chapter, and they've given you a few examples here, but obviously in our paper, straightforward cases typically don't appear, but we will go through them once towards the end of the syllabus. We will just summarize and go through the important case studies once we finish the syllabus, but most cases will start with SEBI appointing an authority. Whether the authority submitted a report or not, they would have issued summons. In some cases, party would have not appeared for the summons. In some cases, they would impose lesser penalties. So that is what is the structure of these cases that are given to you for reference, and that is your chapter 40. Alright? So 2 chapters done reasonably efficiently. We are left with about 4 or 5 next. So I think we will do one more session depending on